welcome to the deep dive. Today, we're going to unpack something really fundamental. Access to civil justice here in England and Wales.
That's right.
We've got this detailed report, and we're going to dig into what access to justice actually means, why it matters so much, and, well, the hurdles people face.
Yeah, the very real obstacles based on what this report lays out.
Think of this as, getting under the hood of a key part of how our society is supposed to work fairly and how it affects everyday life.
Exactly. And it's not just theory, is it? It's about real people, real disputes. Can they actually use the system that's meant to protect their rights?
So our mission today is to pull out the key stuff from this report, make sense of it all.
Make it relevant, yeah. Cut through the complexity.
Okay, so let's start right there. Why is this whole idea of access to civil justice so critical? It can feel a bit abstract sometimes.
Well, at its heart, the civil justice system, the courts dealing with disputes between people or organizations, not crime, it plays this absolutely basic role.
Yep.
It keeps society stable. It's how we sort out disagreements peacefully, enforce rights. The report actually quotes Jen on this. It calls it the judicial machinery.
Machinery.
Yeah, machinery that
Right.
sustains social stability and economic growth by providing public processes for peacefully resolving civil disputes, for enforcing legal rights, and for protecting private and personal rights.
So it underpins quite a lot then. It's not just like high-level legal stuff.
Not at all.
Can you give us some concrete examples, situations where this really bites?
Sure. The report mentions things like, well, imagine being evicted by your landlord without them following the rules, or you think you've been unfairly dismissed from your job.
Okay.
Or really difficult situations like parents disagreeing over child arrangements. Without access to the courts, where do these people go for a fair resolution? The impact can be huge, personally devastating even.
All right, that makes it much clearer.
Yeah.
And the report links this to the rule of law.
Yeah.
How does that connection work?
Yeah, that's crucial. Access to the courts is a pillar of the rule of law. The report uses a Bingham's definition. Basically, everyone, individuals, government, everyone, should be bound by the law and entitled to its protection through the courts.
So the courts are where the law gets real, so to speak.
Pretty much. Lord Reed said something similar in that Unison case courts exist to make sure laws made by Parliament and the common law from the courts themselves are actually applied and enforced.
Makes sense.
So if you can't get to the court, well, the whole idea of the rule of law starts to wobble, doesn't it?
Okay, so we see why it's vital. But, as you said, the report talks about barriers.
Yeah.
What's actually stopping people? What are the main roadblocks?
Yeah, the report points to a couple of big ones, and they're kind of linked. First off, just a basic lack of legal knowledge.
Like not knowing your rights.
Exactly. Or even not realizing you have a legal problem in the first place. Or, okay, you know you have a problem, but where do you even start to get help?
The report had that diagram, didn't it?
Yeah.
Figure 6, showing how a claim can just fizzle out.
That's the one. It really shows how claims can fail just because someone doesn't know the process or doesn't have support. It's not necessarily about the merits of the case itself.
Wow.
And the second big barrier, well, it's the complexity of it all and, crucially, the costs.
The money side, always a big factor. I assume the report goes into that.
Oh, yes. It spells out how expensive legal action can be. You've got your own lawyer's fees if you have one, court fees.
Mm-hmm.
And then there's this really significant risk, the losing party pays rule.
Right, I've heard of that. If you lose, you could pay the other side's costs.
Exactly. Not just your own bills, but potentially a large chunk the report mentions, up to 70% of your opponent's legal costs, too.
70%? Wow, that's enough to put anyone off, surely. Even if you think you have a strong case.
It's a massive disincentive, a huge gamble for most people.
So what about legal aid? Isn't that supposed to help people who can't afford these costs?
Well, yes, that's the idea. But the report makes it very clear that the landscape for legal aid changed dramatically.
Oh, so?
The big turning point was the Legal Aid Sentencing and Punishment of Offenders Act, 2012, everyone calls it, LASPO.
LSPO, right.
It led to really deep cuts in what legal aid covers. The report says it basically halved the number of acts of assistance provided.
Halved. That's a huge reduction.
It is. Think about advice centers, help with housing law, family law, much less funding available across the board. So fewer people getting help.
And the aim was just to save money on the legal aid bill, presumably.
That was the stated goal, yes. Lowering public spending in that area.
But did it work out like that overall? the report seems to hint otherwise.
Well, that's the complex part. The report suggests that while LASPO cut the legal aid budget, it might have just shifted costs elsewhere.
How do you mean?
Increased spending in other public services, maybe unemployment benefits if someone loses their job unfairly and can't fight it, or healthcare costs linked to the stress of unresolved debt or housing problems.
I see. The knock-on effects.
Exactly. And then there's the human cost, which is harder to measure but very real. The stress, the anxiety, the health impacts when people can't get legal help.
The report mentions exceptional case funding, too. Is that like a safety net?
It was meant to be. It's for cases where not providing legal aid would breach someone's human rights or EU law provisions.
Okay.
But getting it is tough. The report highlights that the process itself can be really difficult to navigate, sometimes needing the very legal expertise the person is trying to get funding for.
Bit of a catch-22 then.
It can feel that way.
Yeah.
And there was that case, the Gudena case the report mentions, which basically said caseworkers need to properly look at the individual situation, not just assume funding shouldn't be granted.
So with legal aid reduced and costs being so high, what else can people do? Does the report look at alternatives?
Yes, it does cover other avenues. There's alternative dispute resolution, or ADR.
Like mediation.
Exactly. Mediation, negotiation, trying to sort things out without ending up in a full court battle, which can be great, but it's not always suitable or successful.
And what about places offering free advice, like charities?
Absolutely vital. The report stresses the importance of not-for-profits, like Citizens Advice. They do incredible work,
Right.
but their resources are often really stretched. They just can't meet the sheer level of demand sometimes.
Okay. What else?
Then you have pro bono work. That's lawyers giving their time for free.
Right.
And the report cites a figure, I think it was from 2017, estimating something like 439 million pounds worth of free legal help was provided that year.
Wow, that's a lot of free work.
It's substantial, shows real commitment from parts of the legal profession.
But the report questions whether that's sustainable or even right, relying on charity for access to justice.
Precisely. It raises that ethical point. Should a fundamental right depend on volunteerism? It also mentions university law clinics, like the Open University's Open Justice Center.
How do they work?
They often involve law students, supervised by qualified lawyers, providing free advice and representation. It's great for the community and good training for the students.
Okay. And those no-win, no-fee deals we see advertised.
Conditional fee agreements, or CFAs, they definitely help people overcome the barrier of upfront costs because the lawyer only gets paid properly if you win.
Sounds good.
It can be. But the success fee the lawyer takes usually comes out of the compensation you receive. The report notes this can mean the claimant ends up with less, sometimes significantly less, of their damages.
Okay, so it's not always a perfect solution.
It's a trade-off. And finally, the report just touches on legal expenses insurance before the event or after the event policies. But again, you generally need to be able to afford the insurance premiums in the first place.
Yeah, so not accessible for everyone. Now, something else the report raises sounds really concerning, this idea of the geography of justice, or legal aid deserts. What does that mean?
Yeah, this is a really stark point. It highlights massive inequality depending on where you live.
So some areas just don't have legal aid providers.
Effectively, yes. Particularly for certain types of law, like housing or community care. The report states that over a third of the population in England and Wales doesn't live near a housing legal aid provider.
Over a third? That's huge.
It is. Think about it. How can you realistically access justice for a housing issue if the nearest help is miles and miles away, possibly hours? It completely undermines the idea of equal access under the law.
It really does. Okay, shifting slightly, the report also discusses tribunals. They were meant to be simpler, cheaper routes, weren't they?
That was the original intention, yes, for specific areas like employment disputes. Speedier, less formal, more affordable than going to the main courts.
But the report suggests that wasn't always the reality.
Well, that access got undermined. The prime example given is when fees were introduced for employment tribunals back in 2013.
Yes, I remember that. And what was the impact?
Pretty dramatic. The report highlights a massive drop, a really significant fall in the number of people bringing cases to the employment tribunal.
So people were just priced out?
It certainly looks that way. People with potentially valid claims for things like unfair dismissal or workplace discrimination simply couldn't afford the fee to start the process.
But didn't that get challenged? That brings us back to the Unison case, right?
Yeah.
The report flags that as important.
Hugely important. The Supreme Court stepped in. In R. Unison v. Lord Chancellor, they ruled those fees were unlawful.
Unlawful, why?
Because they effectively prevented access to justice. The court found they were unaffordable for many and breached that fundamental common law right to access the courts. Lord Reed also emphasized that tribunals aren't just about the individuals involved, they serve a wider public good.
So upholding rights in tribunals benefits society generally, not just the person bringing the case.
Exactly. The judgment really hammered home how crucial accessible courts and tribunals are for the rule of law. It wasn't just about the money, it was about principle.
Okay, so pulling all these threads together from the report, what's the bottom line on accessing civil justice in England and Wales?
Well, the report essentially concludes that the biggest hurdles remain cost and lack of legal knowledge or awareness.
Right.
And while the civil courts are there and are vital, these barriers mean lots of people just can't use them effectively.
And LASPO made things worse.
According to the report, yes. It exacerbated the problems, contributed to these legal aid deserts, and increased reliance on alternatives like charities or pro bono, which, while valuable, have limits.
But the Unison case offered some pushback.
Definitely. It was a critical reminder from the highest court about just how fundamental access to courts and tribunals is. It underlined that this access is essential for the rule of law and a fair society.
So the final message from the report is
That these barriers cost, knowledge, geography, they need to be actively tackled. If they aren't, the civil justice system can't really fulfill its purpose for everyone.
that's a really clear summary of a complex issue. So just to recap this deep dive,
Mhm.
we've looked at why civil justice is so important, basically underpinning fairness and stability.
Mhm.
We've explored the really big obstacles, the sheer cost, not knowing your rights or the system, and even where you live making a difference.
Those legal aid deserts. Yeah.
We saw how legal aid changes under LASPO had a major impact and looked at the alternatives people might turn to, like ADR or pro bono, and their own limitations.
And that key Unison ruling about tribunal fees.
Exactly. Reaffirming that fundamental right of access.
So perhaps the thing to leave you thinking about is this. What does it really mean for us, for society as a whole, when large numbers of people can't actually use the legal system that's supposed to be there to protect them?
Right.
When resolving disputes fairly or defending your basic rights becomes practically impossible for so many? What are the consequences, not just for those individuals, but for the health of our democracy itself?